Is your lawyer being a gatekeeper? Your story is your story. And sometimes lawyers tend to ask you to not present some information to the court. Today, we'll be talking about lawyers who gatekeep and keep your full story, all the facts from getting in front of a judge and how this could be bad for your case. Welcome, Mum.
Hello, Laura. Hi, everyone.
Now, Mum, we're a little bit cross and angry. We are actually quite cross and angry because this is coming up a lot at the moment. And I think we need to address it for a number of reasons. One of them is that there may be a new case that's coming in that could affect property settlement as well as children's matters. Is that correct?
Well, not really a case. It's a bill of legislation that's currently before the lower house of parliament in Australia. So it's not a case yet and it's not even law yet, but it's coming, I think.
Okay. So we all need to be mindful. And even if you are not in Australia, you need to be mindful if your lawyer is actually being a gatekeeper of the information and their job is to present your story. But before we get started, we've got two disclaimers today. Number one is this could potentially be triggering and distressing for those who are victim survivors of family violence. So please be aware of that. And if you feel you need support, you can always call Lifeline or you can call 1-800-RESPECT. The second disclaimer today is around the fact that this is legal education, a discussion around how to use lawyers and how to present your story. Yeah. Everybody's situation is different. So we strongly recommend that you do listen to your lawyer's advice, but maybe potentially you listen to this episode and it resonates with you. Think about getting a second opinion and we'll talk about that at the end. But we're just putting the disclaimer out there. Don't go and say, oh, I failed my case because I listened to the divorce course. We're saying don't do that. Just be mindful of this.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
All right, Mum, so let's get into it. I don't come across particularly mad, but I'm angry because there is this situation at the moment where people are saying to us, like the notice of risk that they have to fill in.
Yeah.
Their lawyers are saying don't put anything in. Or the affidavits, there's things that have happened to these people that probably the judge needs to know about. And the lawyers are saying, do you really want to put that in? So we're a bit annoyed by it. So that's why we're doing the episode today.
Yeah.
Can you explain to me the role of a lawyer and the role of a judge and why people need to be aware of this? And then we'll talk about the cases and things that can happen and what to be aware of when going through your divorce custody journey.
I'm counting on you to keep me succinct and on track.
Trying.
Okay.
So just tell me, what's the role of a lawyer and what's the role of the judge and where do we see this gatekeeping happening?
Okay. So, of course, the role of the lawyer is two things. One, to take your instruction, get your story down, get your side of the story, what case it is. And secondly, because it's a two-way street, to advise you on the law, right? So it's a kind of flow of information from you to your lawyer and your lawyer to you. With the information recorded upon the solicitor's advice, right, tailored according to the solicitor then puts that material before the court. That document becomes your evidence, so you don't have to get up in the witness box and say it all again. And the judge relies on that evidence to make decisions about your case. And if you don't say what happened, how can anyone know what's needing to be done?
So that's why we're doing it today, this gatekeeping situation. Why are lawyers leaving some of this stuff out, do you think? And I know you like lawyers and you advocate for them. Why are lawyers pushing? What are you seeing? What is their reasoning? Is it because they don't understand the law? What reason is it?
My heart wants to say gutless.
Oh, Mum's mad. Mum's mad.
Because you say that. So say the person on the other side has got one of these pushy, nasty lawyers, barristers and everything, and your lawyer's feeling a little bit like threatened by them. And so they don't want to speak truth to power. And they might be lawyers who like to settle everything. And they might say, what we see is a little molehill. If I say that, if you put that in, it's going to blow up. But it happened and it's in there. So if your lawyer gives you, though, advice that it is not going to be needed as part of the court proceeding, say it's not relevant, then that would be sensible to leave it out.
So we'll get into the reasons why they might say and the reasons why it might be sensible, but let's talk about the reasons that are not right in our view. So one of them is you're saying they're gutless, they're scared.
Yep.
Now the reason I've seen is the affidavit is only 10 pages long.
Isn't that so? And if you're in a family violence situation, isn't that the first thing that should go in? Isn't that the first thing that should go in? We're letting people down by saying that it's like an also-rans. Family violence colours every single step of a person's divorce journey.
And that takes us to the third reason sometimes where they say it, and that is because they go, oh, this is property. This isn't children's matters. So if it's property matters, so why is it important for you to push your lawyer to double check about this situation when it comes to property? Why should it be mentioned?
It should be mentioned because it may be that family violence directed at our client has made it so much harder for that person to make the contributions to the family wealth. So it is part of your contribution. I guess you get an uplift in your contributions if they were made harder than it would have been for someone who didn't have a jerk for a partner who was violent towards them.
So what you're saying is, Mum, and this is the case we're going to be talking about a little bit later, there's this legislation that was put in front of the Australian government they're talking this morning or yesterday, where they want family violence to be considered when it comes to property and a larger share percent given to anybody who's gone through DB, because obviously it's obvious that they're going to struggle, during and after. So, Mum, you were saying one of the reasons everyone needs to be pushing for their information to be true, accurate, and not gate-kept is this could come in, couldn't it, whilst you're still in court?
Well, even if it doesn't pass, like what this legislation is trying to do, as far as I can tell by reading the bill, and remember, it might come out totally different. It's trying to take the principles of Kennan's case, which is a famous 1997 case, that said that a person's contributions, they say a woman's contributions were 50%, right? And then they say, but because of what she was having to cope with at home, it should be 60%. We'll give her an uplift of 5%. So Kennan's case still applies. You just have to be able to draw the connection between what happens in the home and how that made your work harder. I think the other thing that might work is that if and when this comes in, and particularly since people are doing like Kennan arguments already now, is it might make people who are prone to coercive control or domestically violent interactions, it might make them pull their heads in because it's going to tell at the end of the day in court and give them a lesser share of the property pool.
So if anyone's listening today and you're in Australia, bring up Kennan's case. If you have experienced family violence, that is something you can say to your lawyer, look, have you seen Kennan's case? Because I do think there's a lot of lawyers that don't know this sort of stuff. And they go, well, domestic violence, that's not property. We're just dealing with some numbers, not with your experience.
In their defense, Kennan's case was out of fashion for a while, or it was very much confined to its fact. And so it was a very difficult thing to prove. You had to practically have a broken bone or something. But over the last 3 to 4 years, the court is being more open to having regard to those things. Someone who's not completely up to date maybe is still stuck in the old way of Kennan's case. I think every family lawyer knows Kennan's case. I hope they do. But you might need to say to them, how does this fit in with Kennan's case for me? Like with the latest cases or with this new legislation. If you don't put it in early, then you leave yourself open to attack from the other side. Say, why didn't you put it in earlier? And you're going to have to say, if you haven't put it in and you're putting in an affidavit now with it, you're going to have to say, my lawyer advised, that's if it's true, my lawyer advised me not to put it in. And there was this time, Laura, with children from about 6 to 2012, I think, where if you complained about family violence from your ex-partner, the court was entitled to regard you as an unfriendly parent and less likely to support the relationship with the other parents. They all kept mum.
So a lot of lawyers were like, don't talk about it, don't say it. Because let's be honest, there is a playbook, and we've talked about the narcissist playbook in divorce and using children as chess pieces in divorce.
Classic.
And one of the things that happens is if someone does come out and say there's been family violence with post-separation abuse, they then turn it into, oh, she's alienating or they're alienating.
Yes.
And whilst there are situations where children mind messed with, that's not a common occurrence. And parental alienation has been proven to be not a thing. There may be things, but it is not that. So there are all these things where they'll say, oh, are you sure you want to say that? Because maybe that will make you sound crazy. And you're right, Mum. And I don't know if people understand how long a court process can take, but it can take years.
Yeah.
And we've come across people who have gone through this for years. And I hope for you listening today or watching today that yours is quick, easy, and painless. But if it's not, you don't know yet. And if you're not upfront and honest about everything from the get-go, like something could happen 2 years down the track. And then they'll say, well, that's the first incidence of it ever occurring. There's no pattern of abuse because this is a one-off incident. And then what are you going to do?
That's right. And what are you going to do then? And you've been guided by your lawyers all the way and haven't raised it. The other thing it does, Laura, if you don't speak up, right, when the kids perhaps go to a family report writer, they may not be believed either, or they may not be asked about those circumstances. Whereas if you put your material in your affidavit, even if it's a sentence or two saying he used to hit me all the time or she used to do, then the family report writer has a full box of crayons then, and they can ask the kids about these things and get that corroborative evidence because chances are they saw it.
Now, there's one thing we're not talking about. So yes, so support your children by being upfront and honest about what's going on and stand in your truth. I think
yes.
Problem with not telling your lawyer or the problem with your lawyer not telling the court is that it continues the dynamic of family violence.
It does.
You are coerced into being silent. You are continuing to be afraid of not rocking the boat. And I think when you get to court stage, you're rocking the boat and your lawyer's going to have to rock the boat talking about property. So you might as well just rock the boat if it's safe. But I think the only place where you can get the help really is in a court. And it is with, law enforcement by being upfront, being honest and getting it out there. Mum, have you ever seen a situation where there's been a case where they haven't ever been given the full facts and the outcome is unfortunately different because the facts are missing? Or have you ever seen that kind of situation?
Yep. Coercive control victims often don't realize that was what was happening. And so way down the track, they've realized that they've actually compromised their case because they were scared of the other person or they were under the control. And they would come in, I'd see them occasionally, they'd come in to see me, we've done this agreement, and now I think I didn't really get enough and I shouldn't have agreed, but they did agree. And there's binding orders. And it seems weak to say, I forgot to mention, I was bullied into signing these documents, Section 79A, if it's a marriage. And the court has a very keen sense of that litigation, particularly repeated litigation, is dangerous and expensive and life damaging. And so it is very hard to overturn something that's already been agreed on. It's really hard. So then these people live with that regret all their lives. And in this case, that's not the lawyer. That's a person who didn't say. But, even your very first couple of documents you put into the court, right, in a proceeding, allows the court, they triage. So they look through, see if there was family violence, whether it's property or children, and they put them in appropriate lists. The family court's doing an amazing job now of picking up those cases where there is a small property pool and moving them through quickly, picking up cases where there appears to have been significant family violence and putting that in an area where one person tends to oversee the case as long as they can.
Okay, so that's called the
evidence list.
The evidence list, and then the P500.
500 or PPP 500.
You've got under $500,000, that gets sped through. If you get, then the EBITS list is, if they see it is victim survivor situations, extreme violence, then they will expedite the situation for you. So that is another reason to be honest, because you don't want to be stuck in a dynamic with a violent ex or a post-separation abuse situation for 5 years because you didn't get put on the EBITS list.
Because no one noticed. That's exactly right. And do you know too, I mean, the court is used to people, like they think some people will reframe things when they're talking about the past. So the only objective evidence the court will have is what you've said in your affidavit, and did your doctor or someone refer it to the community children's services in your state? Did it get reported to the police? And you and I know, Rose, coercive control, Jess Hill, that it's not something that you can see. And each little event just seems so minor. I can't even think of the stuff that would, on its own, just doesn't count for much, but it is an overall pattern, and mostly it's how you feel. So,
Mum, for those who are listening today going, yes, that's me. My lawyer is totally gatekeeping the information. And, we're only talking about family violence here, but there could be gatekeeping of other information that you might think is relevant or important.
Yeah.
So just be mindful. So what I'm going to do, Mum, is I'm going to pretend to be the lawyer, and I want you to give the answer these people should think about when they do this, so that if you are listening today and you're like, yes, my lawyer is gatekeeping the information to the court, how do I go about it? This is what I'm going to put you on the spot here, Mum. All right.
So you're the lawyer.
So you've just told me some information.
Yes.
And I'm going to be the lawyer, and I'm going to say, but that was in the past. And has it happened since you've left?
Well, not as such. But it was such an awful thing that I've lived through, and, I'm only just realizing it. So I want that information in if it's relevant. If you think it shouldn't go in, though, and I know that you're a family law specialist of some note, can you write me an email and tell me why?
All right. You've come in, you've seen me, and you've told me your story.
Yep.
That doesn't sound that bad, though. I don't know if we should put that in because it doesn't really sound like a big deal.
Well, it was to me, and it's why I moved from town to town with them. That's why I never got a job, because I was told to stay home, all of those things. So it is really relevant to me. And I've been listening to this podcast. And maybe you should, take some notice going through the government at the moment, what's going through Parliament.
I really hope just one person gets a better outcome from this podcast. But let's do another one. Are you sure you want to bring this issue up? Because they're going to put you in the witness box. They're going to ask you embarrassing questions. They're going to really pressure you. They're going to make you feel like you might be crazy. Are you sure you're emotionally stable enough to go through this? Really, it's going to be a lot of extra work. It's going to cost a lot more money.
I need to tell the truth. I want to tell the truth. And, if they didn't want me to talk about it, they shouldn't have done it in the first place. And I'm gradually, the more distance I'm getting from it, the more I'm starting to get quite angry. I'm confident I'll be fine in the witness box.
Next question. I don't think what you're telling me is relevant to anything that we're doing. I'm just going to cross that out.
Well, hang on a minute. This is my affidavit we're doing here. Can you explain to me why you want to take that out? Because to me, it's pivotal.
Brilliant. Are there any other reasons, Mum, you can think of?
For what, darling? For the lawyers? Oh, give me the lawyer again. And while we're at it, he took all of my Tupperware deli mold. That's just not on. And I want that in the affidavit as well. And I'll be the lawyer, Laura.
Okay, you be the lawyer.
I can see that's quite hurtful, but that is chattels and goods. The court doesn't really get involved in those little things. However, the fact that he took something that was valuable to you is part of a pattern of coercive control. So if you like, we'll put that in and see if we can build a pattern from these little incidents.
Okay. Is there any part of the Family Law Act or any cases, and we've just discussed one anyway, that our listeners could say, hey, maybe you should take a look at this?
Yeah. I think it's Kennan's case and all the subsequent ones that have come through since Kennan. So it I've been looking at Kennan's case this morning, and it's been used in many, many cases for a long time. But Kennan's is still the high watermark, so to speak. It's good law. So just get them to look at Kennan. And I think I'd be saying to them, have you looked at some of the decisions over the last 3 or 4 years with Kennan? The court is not requiring, as far as I understand, an actual causal, like this person yelling at me caused me to lose my job or caused me to be upset and have the high depression. The court's just being a little easier on seeing those things now. I think it's since coercive control has begun to be recognised, they can see that sort of, it infiltrates everything, Laura. It infiltrates when you're doing children's matters, property matters, maintenance issues, child support. I mean, that's one of the beauty of child support is you don't have to fight your other party. If you give it to the agency, they can do that fighting for you. But yeah.
What about people who are self-repped? And again, we strongly recommend you go see community legal if you can't afford it, so you can get some advice. And this is not advice for you being self-repped, but how do these people respond if they have put their story forward to the other side? Maybe the other side has a lawyer and those lawyers write back and go, well, that's irrelevant. There's nothing.
Kennan's case, just right.
And how do you spell Kennan?
Kennon, and apostrophe S. And also, with fingers crossed, this new bill that is currently going through Parliament maybe come into law, and no one will be able to say it's not relevant because it will enshrine actually in the legislation that a person's conduct during the marriage can mean their contributions were harder. Do you know why they took so long, though? Can I tell you? I've forced myself to read Kennan's case from beginning to end today because I thought I refer to it all the time. But they give a nice little history, the full court does, of things. And a lot in the early stages, because this was a no-fault divorce, the 1975 Family Law Act was no-fault divorce, as opposed to pre that where you had to prove desertion or cruelty or whatever. So no-fault divorce. They kind of misinterpreted to say that you're not allowed to allege anything about the other person's conduct during the marriage. So Kennan's case turned that on its head, but it was like in limited circumstances. And then gradually the courts have begun to make more findings about Kennan. And it's a global thing. And I think that everything's harder if you come home to a person who's mad at you.
And I think if everybody is honest and everybody speaks up and everybody tells their truth, particularly as well as women as well as men, because I know there is a small percentage of men who experience this and they feel embarrassed, I think, to raise any of this in front of any.
That's for men, Laura. They're less likely to go to the doctor if they've been assaulted and they can feel really depressed and they don't have the solid responses that we have begun to build for women because it's majority of women who are suffering it. But when I've represented male victims in court, it's sad how often I'd be told to take my client up to the end where they were keeping the perpetrators or alleged perpetrators. And I'd say, no, here's a victim. Oh, well, we haven't got a room for male victims. There's a lot of it around. I know that.
Yeah.
But it's relevant.
If every victim survivor speaks their truth at the start, I think the push will get bigger and the pathway forward for the next, hopefully less and less people will be better. And that, I think, before people are filling in court documents, Mum, they're going to mediation. Do they raise this in mediation?
Yeah. Well, I think if it's safe to do so, and that's one thing I was thinking with, we're very firm on people. Yes, speak your truth. But if you know that doing that is going to put you at risk of your life, then the court's rules, the court's whole central practice direction says, don't do anything that would endanger you or endanger your family. So you might not put in your notice of abuse, for example, for children, you might leave out some things because if you put them in, you don't know what might happen. And the court allows for that. You can send an email to the registrar and say, I didn't put that in this document, these things that happen, but they did happen and I'm not safe.
So what you're saying is when you go to file it, instead of putting it in the notice of risk, which is you have to fill in a notice of risk, whether there is any or not. You then attach that to an email to the registrar of the family court that you're filing in and say, I can't put it in because I'm in danger. Can you please be aware that this is a thing? I just can't put it in. Is that what you're saying? And then that way you're protecting yourself.
You are protecting yourself, yes. I mean, you just have to check with the registry, see how they want to run it. So you're not allowed to leave any of the questions blank in a notice of abuse and risk for children. So you can either say no or nil or yes and explain. And so, but to avoid the court thinking there's nothing wrong, my suggestion is that you write to the registry. You say, I've lodged my notice of risk. Okay. However, because I'm afraid, these questions, and list them out and change the answers and say, this is my real answer, but it's really for the eyes of the court. At the moment, I don't mind it, maybe seeing it later on, but just at the moment, I'm not safe. Something like that. The court will have processes. Yeah.
Okay. And I think it's important to touch on this in case anyone's new to the whole world of this.
Yeah.
Telling the family court that there's DV the family court cannot give you a protection order. That is a completely different court.
Yeah. I guess that's all we used to have years ago. The family court made an order that a person not molest, or I can't remember what the other words are, but follow, interfere with, or whatever the other person. And that was all we had. And that was, the court would make those orders, but it's a federal court. And the state police would go, nothing to do with us. So the women and men would ring and the police go, we can't do anything about it. It's federal law. So then in the late 1980s, they started introducing family violence legislation throughout Australia, and they now do that. It's funny, isn't it, though? One of the things I believe it's in this current bill, hopefully it gets through, is that the family court now and your state courts operate like silos, and they don't really talk to each other. And one of the pushes that's coming on is for the family violence courts and the family law courts to be able to exchange information in real time between the judicial officers so that you don't get those two disconnecting stories. And you have sad cases where you find a person can't get a family violence order, but the judge, after cross-examination, says there was family violence, or he says, like you said, there's no evidence of family violence. So you don't need your judge to be ignorant on either side of what's going on. If it's in the state courts, you want them to know what's happening in the other court.
So to be clear, at the moment, the legislation hasn't been passed. The family court deals with custody and property, and your DV situation may affect the outcomes of those. And then the magistrates court in your state deals with domestic violence and family protection orders, etc. And they don't really cross, so you would have to go to both. But you're saying in the future, maybe you would only have to go to one to deal with it all.
No, I'm not saying that. I'm saying that those two silos will have a bridge between them. And so if you've got a case running in the family violence courts, then that information will be available to your family court judge and the other way around. Because I think that playing both ends against the middle was something that some very manipulative and controlling people do. And
so what's that strategy? Can you explain that? Because we're seeing this a lot. Yeah. People are going into DV court to deal with the domestic violence side of things. But because they've left, they're then also dealing with property and children's matters. So there are two courts at the same time. What is the nasty strategy that you're seeing a lot that people need to be aware of?
I think sometimes they will adjourn the family violence so that there isn't a finding about them being violent, because that will impact on their children's time with their children. Now it's going to, if the law comes through, they're going to do the same thing, adjourn. So there's no hearing or no finding about his or her family violence. And that means the property really will probably be settled before the family violence thing will be. So we've got to tidy up our timelines a little bit, but that's one strategy they can use. Or they say completely different things in the completely different courts. I've seen it. I can't believe it. I see it. And
so how do people counter that delay and the contradictions between the two courts? Can you show the other court what's going on?
there's a thing called a Harmon undertaking. And as I understand it, means you're not allowed to use documents from one court case in another court case without permission. I know. So what you can do, though, is be clear about what applications are in each court. And if you're putting your family law one together, mention there's an application in the family court, say who's the aggrieved and who's the respondent, and where it's up to, when was it lodged, how many adjournments and why. Why has each adjournment been granted? And then let the court draw their conclusion that there's a deliberate dragging of the chain over there.
Okay, so you said family court, but you mean magistrate's court. So in your family court doc, say, I'm in the magistrate's court, this is the case, this is when it was filed, this is how many adjournments it's had. And so then they can see and they can see the pattern, because it does seem to be something that's happening a lot. And it must be a playbook, like the lawyer's playbook.
Sure there is. And I think at the end of that, where you paint the scenario for the family court every time, right? So that if he says, we have to wait until the family court proceeding or till the DV's heard, or we need to get on and finish off this family court stuff before, and they're sort of time for matching them up. I think you just need to say those things. You need to set it out clear. And then I think you need to let them know how you feel about that you find them distressing. It cost you this much money. It's drained our property pool of funds for both parties. They've turned up with a barrister every time. Just all of that sort of stuff. Just to paint that picture of a person who is controlling and manipulative and managing the system. And I believe I'm really excited that I'm still in the law in a way to see these big changes coming through. I'm really pleased.
When it comes to Kennan's case, Mum, can you just give us, and I know on Patreon, if anyone hasn't seen us, we're on Patreon. We've got the link down below that you can find us there. Mum does Cases Explained, which sounds like some sort of science fiction thing, but no, it's legal cases explained. And she talks you through the actual, because you can look up cases and they're just lots of document worded, makes no sense. So Mum explains it, and so you can get your head around, okay, so this is a case, so mine might be similar, this might happen to me, or you can refer to them. So Kennan's case, Mum, people can go and learn about that on Patreon. But can you just give us a little short mini
summary
explanation?
Okay. So the facts of the case were that it was a 54-year-old man's fourth marriage, a 36-year-old woman's first marriage. I think she was on TV, and they were only cohabitation to separation was only 5 years. No children, no combining their property, really. She had not much when she got together with him. He had quite a bit when they got together. She, in the lower courts, that is in just the single judge, she put in evidence of all of these times that she'd been assaulted. And in those days, in 1997, the court said, well, you'll have to prove each one and what happened. And they found that 3 of them were proven and the others were not. And we all know family violence takes place behind closed doors, not in front of people. Anyway, as a result, the judge gave her an award for the fact that her contributions were so much harder because of what she had to put up. He appealed, of course. And it was a very good full court. And the full court said, you know what, that is relevant and good on him for doing that. We don't think there's a problem with doing that. And that really opened the gates. And then for years, the court, I guess, or lawyers have been trying to tamp it down and go, it's only in those very narrow set of circumstances. But now it's opening up, and it should be mentioned to your lawyer if they haven't mentioned it to you. And in the Patreon one, Laura, I show you how to use the case, because I put them up from Osley, and how you can do more study about the case and find it in law sites and CITE and that, and just see how often it's been referred to. And it's been a lot, Kennan's case. Yeah.
So that's good news, I think. We can see the way forward.
Yes.
You're saying that, though, there are so many people at the moment who are in what they call high conflict court cases, but it's not high conflict. It's post-separation abuse. It's a continuation of the family violence into a new space, and that is through the legal system, plus goodness knows what else they're facing. So we know how hard it is for you guys. It makes us so angry on your behalf to see the way that it is dismissed by many. And I'm just going to say it, Mum, there are some great lawyers, but maybe they just don't get it. They just don't get it. I feel like that's what it is.
Look, I can tell you that's obviously the case and a lot. But I can see I can see in the central practice direction, and I can't believe that we nearly got through a whole podcast without me mentioning it again. But
the central practice direction,
in that, the court is leading the way, showing the practitioners what is needed to be done to protect the people. I think it's a top-down education, and hopefully our judges and the registrars and so forth all are aware now of the actual awful impact of coercive control and other things on every area of their life. And the court can't make findings or rulings on things unless someone appeals. So if Mrs. Kennan hadn't taken it to the full court on appeal, or if Mr. Kennan hadn't, taken it to the full court on appeal, that case may have sunk without a trace. But because it got up, someone had deep pockets and took it up to the full court, and words from the full court's lips drop like pearls. And we're all stuck with the full court decisions. And sometimes people take cases up to the high court, but this one only went to the family court.
So do you think that sometimes lawyers believe their ex's lawyers instead of their clients? Do you ever get that vibe where they just say, oh, come on, that's just so ridiculous. There's no way that could have happened. And he's saying this, are you sure? Like, because I think sometimes lawyers are an extension of the people they're acting for. I know you say it's not good to be a gullible mouthpiece, but they are only going on what they've been told. And sometimes if a manipulator is very good at manipulating, they're going to manipulate their lawyer. And then the lawyer in turn is then going to try in turn manipulate your lawyer.
That's right. So that gullible mouthpiece is actually something that was in a case, I think. It's an expression that a lawyer is not just the gullible mouthpiece of their client. When you write a letter to the other side, especially if your ex has found a lawyer that's a perfect match for your ex, when your side writes a letter to them, you need to sort of speak your truth. But really, you're not writing it to your ex because he already knows. I'm sorry, guys, I keep saying he, but it is mostly he already knows what he did and he knows what happened. And as I say, if he didn't want you to talk about it, he shouldn't have done it. So you're not writing to him. When your lawyer writes back and says, well, as a matter of fact, this happened, and that's not true, you're writing to convince his lawyer that his client is a dud. And so you'll be putting your evidence in there, or you may have proof. That's what's so upsetting sometimes with really bad, like manipulative people. They'll just say the most outrageous things and you can prove they're wrong. So I like to put that proof even on the two or three of the points in an early letter to the other side. So the lawyer gets him in and goes, now, mate, what about this? You told me that. And the lawyer, according to the central practice direction, if your client's not being candid and is wanting you to do stuff that's not in the spirit of the Family Law Act, you should stop acting for that client. So we need more brave lawyers.
And I guess if you can convince their lawyer, they will then educate their client on their chances of XYZ in court.
Yes.
And it may end up getting you out of court and settling earlier. So whilst I know a lot of you are just like, oh, just even bringing it up, I've had so many people dismiss me. I've been to the police. No one cares. No one's listening. Why should I even put effort into writing this? Writing to the lawyer, putting your story in there could very well stop the court conveyor belt, and it could get you an outcome that you want quicker than waiting until some big bang happens again and then you having to tell everything. And then by then it's, you should have done it sooner. And I know we're saying you should, which is so unfair, and everybody needs to do what they can do physically and emotionally because your situation is horrible and what you're going through is horrible and you need the support, and we get that. But if you can get someone to help you present your case to their lawyer so their lawyer can go, come on, stop this, or you're not going to get what you want in court, so you might as well settle. This all could help it go away to an extent.
It could. Look, it is what it is. And, if it needs to be said and you can do it safely, it needs to be said. If the other lawyer, having got irrevocable proof or irrefutable proof that your side of the story is correct on some things and their client isn't, they've got two options as I see it. One is to write and correct the record with you or further instruct as my client this, or they should discontinue acting. And sometimes you'll see the very aggressive, manipulative person on the other side will have 2, 3, 4, 5 lawyers, one after the other. And it's often the case that it's because that lawyer's called them out on their rubbish.
And they don't like what they were told.
They don't like what they've been told.
We do hear that a lot. They're like, my ex has got this 6th lawyer in a row and I don't understand. And their case has gone on forever. Yeah, that might be the ticket. Mm-hmm. So, Mum, I'm sorry, but we have to stop it here. And I know this whole episode was about manipulating and controlling people because it's family violence. And if you are a victim survivor and you're listening to this, I hope we've treated it with the respect that it deserves. And we know that the trauma you go through is unexplainable to anybody else but yourself and maybe family members that were with you at the time. And we hope that you get through this and you find your strength and you find a way to stand up, share your story with your lawyer, presenting it in the best way possible, not gatekeeping, so that a judge or maybe settle outside can give you the best outcome that you deserve for going through all that crap.
I agree, Rose. And I wish all of our listeners healing from what has happened to them and what goes forward. And that's the best revenge. They only win if they make you bitter.
And if you want to consider getting a second opinion from a lawyer, if you're like, oh, this is my situation and my lawyer is being a gatekeeper, and you've tried all those strategies we just did before, where Mum did a great job of pretending to be you, you can go listen to our pep talk you didn't know you needed to hear episode, and we give you some strategies on how to find another lawyer. Also, there's an episode on how to choose a lawyer and another one called 5 Red Flags to Avoid When Seeing a Lawyer. And all of those will be helpful. And of course, if you still need more help with post-separation abuse, we have some really good episodes that I'll also put in the show notes for you as well. But thank you, Mum, for your time.
Thank you, Laura.
Fingers crossed that this legislation gets through for Aussies.
I'm very excited. Yeah.
And if it doesn't, don't give up. We will keep pushing. And I wish you all the best. And thank you, Mum.
Thank you, Laura. Bye, everyone.
Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.